Thank you, Madam Chair, and gentlemen, thanks for coming in today. We've talked about the Tenants' Bill of Rights. Some of you have referred to it as a Residents' Bill of Rights. Mr. Burleson, I thank you for mentioning that there were things that didn't get included in the latest version of the Bill of Rights that you support, and I want to touch on those things now. And what I'm going to do is Mr. Taylor, if you would pass these out. We've made a list of the things that didn't make it in, and for the record, we're showing a poster of 7 items, and I would ask unanimous consent that this handout be entered into the record.
Without objection.
A week ago, in response to the directives of this subcommittee and the fiscal year 2020 National Defense Authorization Act, Defense Secretary Esper and the Service Branch Secretaries all signed a privatized military housing tenants' Bill of Rights. Left off, as we've been discussing, Secretary Esper's list were the following, which were included in the Bill of Rights directive in the NDAA that we passed. The first 3 are listed. The right to receive a maintenance history on a property before signing a lease. Second, the right under certain circumstances to enter into a voluntary dispute resolution process that may reduce rent. And number 3, the right to have housing payments held in escrow pending such a dispute resolution. Would you all be all right with all of those? Let the record reflect that everyone said yes. Did you too, Mr. Gill?
Yes.
Okay, good. And then also left off of Secretary Esper's list were several other key tenant protections included in the bill text of the NDAA that we passed, and 4 of those other protections were a requirement that Military Housing Privatization Initiative, MHPI, management companies like you, reimburse DOD for tenants' medical costs if the companies fail to maintain safe and sanitary conditions in the housing that they manage, and you see that. Number two, a requirement that MHPI companies like you pay reasonable relocation costs if relocation becomes necessary because of health or environmental hazards. Number 3, a mechanism where DOD will withhold incentive fees to the MHPI companies if they fail to remedy health or environmental hazards. And number 4, a prohibition of collecting amounts in addition to rent by the MHPI companies other than for amenities, damages, and non-essential utilities. And these are all spelled out in the handout. Do you all agree to those as well? That's in the text of the NDAA.
Yes.
Okay.
Yes.
Congressman, thanks for the opportunity to talk about this. I think generally, as they're written here, high level, we agree with. I think the first issue around medical costs requires a lot more detailed implementation process around that, because it's in how this is implemented rather than a single sentence. So the other things, we agree to these. It's the next level of implementation around who's qualified to make that determination, how is that determination made, where does the information come from. It's all of those things that we are working through.
But you agree with the language?
We agree with the intent, yes.
Okay. And Mr. Taylor?
Yeah. And I'll just add to Mr. Hickey's comments, all of these issues are issues that we are in constant dialogue with Department of Defense officials to sort through what that process looks like. Because having the language there is important, but what's important for us in our partnership is determining what's the process that we need to take to embed these into our agreements. And that dialogue is ongoing with all 14 project owners.
Right, that's process, but you agree with the intent and the language, right?
Yes, sir.
All right. Well, thank you, and I'm here to tell you, know that this subcommittee, through its continued oversight, will for every remaining year of your 50-year management contracts hold you to these commitments. You understand that, right? Okay. I want to talk about NDAs just for a moment. You can put the poster down. On March 29, 2019, Task and Purpose online news article included a copy of an NDA, non-disclosure agreement, apparently used for the settlement of a base housing tenant claim by Lincoln Military Housing. The NDA was reportedly presented to a resident at Camp Pendleton Marine Corps Base. The agreement read in part, and I'm going to pass this out, and I'd like a unanimous consent to enter this into the record as well.
Without objection.
Taylor, if you pass that out and make sure Mr. Guild gets a copy. It says, residents agree that they will not file or institute any complaint or demand against Lincoln Property Company, Pendleton Quantico Property Management, or in any way participate in the prosecution of any complaint or grievance against Lincoln Property Company in any agency or other forum concerning any allegation covered by this agreement. Residents further agree they will keep the existence of this agreement and its terms and other information concerning it strictly confidential. Residents shall at all times refrain from making any negative, adverse, or disparaging remarks, whether oral or written, and including all internet and social media concerning the residents or any non-disclosure agreement. Well, Mr. Guild, do you currently use NDAs for the resolution of landlord-tenant disputes that were never actually litigated, but that do relate to health and safety issues in base housing?
I can't speak to what issues, but we have used NDAs, and we've used for for mediation with tenants.
The rest of you, is that also true? Do you use NDAs for disputes that were never actually litigated?
No, Congressman, we have used confidentiality agreements on things that are being litigated.
Right.
But only for those matters.
Okay, the rest of you?
Congressman, we do not use NDAs.
Okay.
Nor do we, sir.
Trailer?
In the customary sense that they tend to get used in financial settlements for protection of both parties, we have on occasion in the past.
I'm talking about non-litigated matters. You have, okay? Do you know? Okay. Will NDAs for non-litigated matters be used with tenants during the execution of the remainder of your housing property management contract with the Department of Defense? In other words, going forward, you're going to continue to use these things?
We haven't used them to date. We won't use them going forward.
Okay.
We will comply with the terms that are spelled out in the NDA regarding NDAs.
We will as well.
We'll comply with the NDA.
We will comply with the NDA.
But you're going to continue to use them, and boys, you understand my concern here. It's transparency. When something comes up, some dad has mold in the family base housing, privatized housing, and there's a resolution without litigation.
Would the gentleman yield
Yeah, I will.
for a
yield.
question?
Yes.
Does the NDAA now prohibit NDAs? Since we're using the same letters, I just want to make sure that I have clarity on the question.
Prohibits them with just a regular lease, but it allows them,
I'm sorry, I think you probably have to come to a mic and answer the question.
the NDA right now prohibits them explicitly for just a regular lease, signing a lease, going into the agreement. But it does allow them, if the matter is in the courts, and you bring it out of the courts with a settlement.
Okay, so maybe, Mr. Cartwright, you could revise your question so that we understand if they're going to use NDAs that are not prohibited by the NDAA.
Right.
Going forward.
And that is the question. You're going to use them where they're not prohibited?
Mr. Cartwright, I just wanted to clarify that we're not using these going forward regardless of the NDAA.
And I'm glad to hear that, because here's a concern. When some...
Mr. Cartwright, would you mind if every one of them answers that question, please?
Pardon me?
Would you mind if all the companies answer that question?
Yeah, please go ahead, each of you.
We're not prohibited. We may have occasion to, because I understand that there is protections for both parties involved, and there is legal custom to use them on occasion.
Congressman, we do not intend to use NDAs, nor have we in the past.
Right, you said that.
Congressman, we do not use NDAs other than for a litigation settlement. We've said that we won't use it going forward.
Right?
And we have a similar view, and any time that one would be contemplated, we would always do so with the agreement of our military partner.
Here's my concern, is that we need transparency. We have to have transparency. If a little extra compensation is given so that you can get an NDA, that's not protecting both parties, Mr. Ailey. That's protecting the privatized housing company. And it's going to hurt the people who need to know about the mold or the infestation or the paint chips or whatever is wrong that led to the dispute in the first place. That's what I'm talking about. I yield back, Madam Chair.
Thank you, and thank you for your indulgence in me helping you ask questions. We tag teamed the last couple.